हो रहा है लो दानिश साहिब। आपकी स्क्रीन जा रही है लेकिन आप वो उसको कर दो ना, गूगल मीट को वो कर दो मैक्सिमाइज। जस्ट मैक्सिमाइज द गूगल स्क्रीन, ये गूगल मीट। हाँ तुम्हें बंद कर दो ना, चल रही है। ठीक है, लेट्स स्टार्ट एंड अलाउ द पार्टिसिपेंट्स इनसाइड।
Okay, okay.
Let's just wait 2 minutes for people to join and we'll start after 2 minutes. All right. Hi, good evening, everybody. I'm audible. All right. Hi. So, welcome everybody in the last workshop of the run-up series of Freshers Reduction Mode 2025. I am Ayush Rana, and along with Priyanshi Jain, we'll be your hosts for this evening. And this particular workshop primarily deals with the art of oral advocacy and courtroom mannerisms. So, we'll help you familiarize you guys with the aspects of the demeanor that one is supposed to carry inside a courtroom. By the word demeanor, I mean the way the counsel is supposed to carry themselves in front of the judges. All right. Before we start, a very great congratulations to all of you for submitting your hard copy submissions and thereby signing up for the oral rounds of Freshers Reduction Note. All the best to all of you, and let's proceed. So, in this particular workshop, we have 8 things which we are going to cover. The first is a general introduction. The second is how to address the judges. The third is how to present your case. The fourth is arguments advanced. Thereafter, the prayer. Thereafter, how to answer the judge's question, things to keep in mind, and general do's and don'ts. Okay, so let's start with the introduction. So we'll be going in a flow and we'll be talking from the point where you'll be entering the courtroom. So when you enter the courtroom, please note that you're no longer a student. You are a lawyer, you are an advocate who's fighting or who's adjudicating for the side that you've picked up. So this particular factual matrix, which has been given to you in the form of Moot compromise of FIM 2025, you have to imagine it as a real life situation and yourself as a real life advocate walking into a courtroom. So walk in with confidence, have a brief smile on your face because I don't think it is going to give out a very good vibe if your lawyer is not confident, right? So let's proceed with how to address the judges. All right. So when you enter or when you stand at the door of the courtroom, you're supposed to ask permission of the bench to approach them or to enter the courtroom. Now, before that, a very important thing that you refer to yourself in a third person. So if I am the counsel, so I would not be like, I seek permission to approach the bench. I'll say it like the counsel seeks permission to approach the bench. All right. So now the question would arise that you have been granted a time slot and you have a speaker code as well. So why do you need permission to enter the courtroom? So the answer to that is that the judges must be busy or might be busy marking the previous speaker or discussing the moot compromise or reading your memorial. So just to grab their attention and just to tell them that you're waiting and it's your turn to speak, you just say the counsel seeks permission to approach the bench. And thereafter you proceed to the podium, which will be situated inside the courtroom, right? So when the judges give you the assent, either by nodding or by saying yes, you acknowledge their assent as well by saying much obliged, your lordship or your ladyship. You say your lordship to a person who's male, and you say your ladyship to the judge who's female, right? And thereafter, when you stand at the podium, now you have to ask for the permission that what will you collectively refer to the bench as? Because as you must be aware, or I should make you guys aware that this particular event has a two-judge bench. So in that bench, there may be a lady judge or there may be a male judge as well. So you need their permission to what you will collectively refer to them as, right? So you ask the permission by saying the council seeks permission to collectively refer to the bench as your ladyship or your lordships. So they'll grant you permission. They'll say you can either refer to us as your ladyships or your lordships. And when they say that, you say much obliged. And then you introduce yourself. So please note, while introducing yourself, you're not supposed to say your names because to maintain the anonymity and to maintain the fairness of this competition, we've ensured that you will be given speaker codes on the day of the event in the registration on the registration desk. And there are. So if you're not supposed to say your name, how do you introduce yourself? So you just say that may it please the counsel for the defendant or the plaintiff. It depends on what side you've chosen. So if you've chosen the plaintiff, so you'll say that may it please the court, the counsel for the plaintiff. In the case X versus Y, may it please the court. This is the counsel, sorry, my bad. This is the counsel for plaintiff or the defendant in the case X versus Y. And the code allocated to the counsel is, for example, Z28, right? So moving on with this, after you've sought permission, after you've introduced yourself, then you come to your presentation of how do you present the case. You guys have already made your written submissions, and while drafting your written submissions, you must realize that there is a structure to it. So when you argue your case in the written memorial as well, you follow a structure. You start with a cover page. Thereafter, you have the index. Thereafter, you have the jurisdiction, then the statement of facts, then statement of issues, then you have arguments advanced, and then you have the prayer, and then you conclude, right? So similarly, like you followed a structure in your written submissions, you have to follow a structure in your oral submissions as well. So when a case comes to a court, the very first primary question in front of the bench is the jurisdiction of that particular case. So by jurisdiction, we mean the legal competence of that particular bench or that particular court to entertain or to adjudicate upon the matter. So in your case, in the case that you've formulated according to the factual matrix, if you are the plaintiff, if you are the petitioner or the plaintiff, you have to justify that the fact that I am coming to this court is legally sound, that this particular court has the legal competence, has the ability to adjudicate on my issue and to provide relief which I've sought. So, yeah. So, jurisdiction, you have to answer one primary question, which is why exactly have you approached this court in particular and why not any other court? So, if you have approached the High Court, you have to justify that why you're approaching the High Court, not the Supreme Court and not the district courts, right? So, then the by this, the statement of jurisdiction becomes a very important part of your oral submission. However, given that the judges in this particular event will be hearing multiple oral submissions, they must be somewhere aware or satisfied with the jurisdiction before you even state it. So the counsel in this particular case can, if they are not, if they don't want to state their jurisdiction, they can ask the lordships or the ladyships, whatever you have sought permission from them earlier, to collectively refer to them as to so you can ask them that if you are satisfied with the jurisdiction or the statement of the jurisdiction, the council seeks permission to address the facts. The facts being the second portion of your oral submissions. The first being your statement of jurisdiction. The second one becomes your statement of facts. So if it is advisable for all the councils to state their jurisdiction because it presents a very learned point of view. The judge will have this perception in the mind that the person has prepared for his oral submissions and has prepared the memorial himself or herself, right? So when you seek permission, the bench may grant it or may decline it. Either way, you have to acknowledge that and you have to say much obliged, and then you move to the facts. Even if you've stated your jurisdiction, thereafter after that, you again ask this question: if your ladyship and lordships are convinced or are satisfied with the statement of jurisdiction, I the council seeks permission to proceed to the statement of facts. So now let's come to the facts. So in your written submissions, you must have stated a very brief structure of your facts according to your own inference. So you've been granted a compromise, but for the sake of brevity and for the sake of keeping your memorial short, you present the bench through your written memorial a very brief outlook of what is the main crux of the problem. So this has to be orally submitted to the council, to the bench as well. So you just say that the council seeks permission to state the facts, and thereafter, when they give you the permission, you start with the facts. That in this particular case, X did that, Y did that, and thereafter this happened, and this legal question arose. The facts are so and so, and you lay down your factual matrix according to your own suitable side. Moving on with that, again, a caveat here is that given that the judges would be hearing multiple oral submissions on that particular day, it might be a possibility that they do not want to hear your facts. So you just give them an option that, and even if it's comfortable with you and you don't want to state your facts and you want to lay emphasis more on your arguments advance, then you can ask the bench that the council seeks permission that if the court is already well versed with the facts, the council seeks permission to state the issues, and through this you skip this stage of facts and then you directly proceed with the issues. All right. Before we proceed, let me just say that if you have any doubts and queries, feel free to drop them in the chat box, and they will be replied there. Okay, let's go with the issues. Now, issues are essentially the questions of law that you as a counsel have raised in front of the bench for them to adjudicate upon that, and they become very important because they are the main crux of the case. That what what questions they are the main questions that you seek answers from the bench. That please answer this particular question of ours which we have raised. So while introducing your issues, you just say that there are three major issues or four major issues, as many numbers as you've raised in your written submissions. And then you say issue number one is that so and so, so and so. Issue number two is this and this. Issue number three is this and this. So after you have briefly stated your issue and you have stated them verbatim, you say that you also state that in this issue or issue number one, the council would be arguing in the affirmative or the negative. Now, why this is important is because issues are generally neutral in nature. They do not lay emphasis on one particular side. If a plaintiff is raising an issue, that will be neutral to both plaintiff and the defendant majorly. So you have to then state that in this particular issue, I, being you, being the counsel of this particular side, will argue in the affirmative of the issue. That whether X has done this, you'll be arguing in affirmative. And if you're the defendant, you will say that you're arguing a negative of that particular issue. This becomes important because this gives a very brief outlook to the bench of your mannerisms and of your approach to this particular case. All right. Then, in the statement of issues only, if you have raised any sub issues, which is not a mandate upon the councils, if you've not raised any sub issues, then also it's fine. But if you have raised any sub issues, then you state them here. After stating your issues, you yet again ask the court that if the court is satisfied with the issues, the counsel seeks permission to elaborate on the first issue. So now you must have noticed that after commencement and after end of every stage, you have to ask permission. Why do you do it? So asking permission is important because then it gives a space and some room for the bench to ask you some questions. Because if you want that your flow is not disturbed by their questions, you give them enough space, enough room for them to lay questions for you and you can answer them therewith. So, with this approach, your flow would not be broken and you will have a very smooth oral submission. All right. That is why it is important to ask permission from the start and at the end of every portion of your oral submission. ठीक है. So, now let's come to the stage of arguments advanced. Now, while drafting your memorials, you must have noticed that while all the other portions of your memorials are barely taking 1 or 2 pages, the arguments advanced form the most numbered pages. Like they're the biggest part of your memorial. And with that, we can infer that arguments advanced are the most important part of your oral submissions as well, because this is the heart and core of your statement of what you're adjudicating from your side in front of the bench. So, in a very initial stage, for a person who's not argued before a bench or has argued in a moot, it is very advisable for you to prepare a note. And what I mean by a note is that not your written submission, not your memorial. Just prepare a small sheet. You write that I want to argue this, and you say that this argument is backed by this legal precedents mentioned in this paragraph number of my memorial, so that you have a paper or you have a index to your memorial, and you can readily refer to your memorial if the judge asks a question. And even when you argue, you can refer to the pointers, and you can easily remember your points and argue them in an efficient manner. And also, the second point in this slide is very important that when you're moving through your arguments, you say the counsel humbly submits, as you must have written in your written submission as well. So, while presenting a particular argument that X has done this, so you say that the counsel humbly submits that X has done this, and so inference with whatever you're drawn from the fact. All right. Then comes the judgment part, which you have cited to back up your legal argument. You are expected to know something or the brief facts and the ratio of the judgments that you have cited and that you have heavily relied upon. All right. So you can't just state the judgment. The bench will ask you the case matrix or the ratio of the judgment to ensure and to satisfy themselves that this particular participant has made the memorial himself or herself. That is the main rationale behind asking you the questions that what has happened in this particular judgment. Priyanshi, can you please answer the query on the chat box? Thank you.
Sure, I'll take
So,
it. Thank you.
thank you. All right. So if the judges ask you a particular question that you unfortunately are not aware about or you don't have an answer readily available with you, so you have a safe play and you can plead ignorance. So ignorance can be pled in two regards. Ignorance can be pled of law, ignorance can be pled of facts. So if the bench is asking me a question that whether X was present at this particular spot on 9:30 p.m. and I, for some reason, have forgotten that whether this is true or not. So I can plead that the counsel humbly pleads ignorance of fact because this is the fact that X was present there or not. Also, if the judges ask you a question which is particularly related to a statute or a law, that what are the essentials of the contract, what is laid down in Section 5, Section 11 of the Indian Contract Act, and unfortunately, or due to some reason, you're not aware as to what is written there. So you can plead ignorance of law therein. But it is always advisable that you don't do it and uh, you don't plead ignorance of the facts that you've stated in your case, the brief facts that you've mentioned in your case, in your written submissions, you don't plead ignorance about them. Also, you don't plead ignorance about the judgments that you have heavily relied upon. Then, why do you plead ignorance if you don't do it? See, pleading ignorance is a very clever tool which you can use. All right. So, if you don't know the answer of one particular question and you feel that I have better arguments coming up and I need to dedicate my time more in those particular arguments, then you can skip the whole mess up of you trying to answer and you not being able to answer, then the judge asking you another question and this to and fro, which consumes a lot of time. So to save this time and for you to invest that time in your arguments further, you plead an ignorance and you'll be like, allow me to proceed to my next argument so that I can lay my case in a more efficient manner. Right. Now let's discuss something more about the notes. The notes are not your written submissions. The notes are just pointers which can be as subjective as you want them to be. It can vary from all of it. It doesn't have a specified format. It doesn't have anything. You can write bullet points that I am going to argue this, I'm going to argue that. You can write the names of the cases, you can write the names or the not the names, you can write the names of the cases, the ratio of the case, the facts, a brief outlay of what has happened in that case. For instance, that if you have stated a case A versus B, in your written submission and you believe that A versus B is a very important case for substantiating your particular argument, then you can prepare a short note as to what happened in A versus B and why you have quoted that particular case in your written submission. And that is very important. Judges are very curious that why have you quoted or why have you cited this particular judgment in your case? How does it substantiate your argument? And you have to answer that particular question of the judge, that this particular judgment is relevant to my oral submission or my written submission or my case. And being henceforth, the counsel being on the side of plaintiff is stronger and so, right? All right. So in the end, the pointer says that any claim should be backed by facts or the law. So while arguing, you just make claims. For instance, when you say the counsel humbly submits, what are you submitting? You're submitting a claim. You're submitting an argument. And that particular argument or claim that this has happened or that has happened or that is supposed that is the way which things should have prevailed. You have to back that up with a cogent argument, cogent judgment, and a cogent fact. Cogent means logical, and you have to derive an inference out of that. For instance, if you are keeping a fact on the table, you need to have the appropriate backup to back that fact if the judge fires back a question counter to that particular statement. All right. So arguments advanced become the most important part of your oral submissions, and this is the part that you have to pay most emphasis to. And please prepare a note or whatever suits you. And let's proceed with the last part of your oral submission, the prayer. The prayer is very important. And all right, before the prayer, let me just also highlight one thing that every council has been granted 10 minutes. It might be a possibility that your 10 minutes are about to end, as the courtmaster must tell you through placards and all that how much time you have left. So you can also ask the judge that the council seeks an extension of 1 minute or 2 minutes to conclude his or her case, and thereafter the judge will grant you some extension, some more time for you to state your prayer or for you to conclude your issues. So it is also advisable that you don't, in your arguments advance, you don't focus only on one issue. You try to allocate time between all issues that you have raised so that you're able to cover them all. However, if you're not able to cover them and you ask the judge or the bench for an extension of time, then you quickly, if whatever the issues that you are left with, you quickly conclude them and then you proceed with the prayer. Stating the prayer is very important in your oral submissions because this is the main crux of what you're asking this particular bench to do. For example, in your written submissions, you must have raised the prayer that in my case, this should happen. X should do this, or X should be directed by the court to do this, and therefore it becomes a very important part because you need to make the judge aware of what you're asking. The judge might or might not read your prayer, but you need to emphasize on it. And even if your time's over, you can always ask the judge that the counsel seeks a humble extension of 1 minute to state the prayer, which will be granted or denied as per the convenience or the discretion of the bench. And either way, that assent or dissent you have to acknowledge by saying much obliged, your lordship. All right. So once you're through with your issues and once you're done with all of them, and almost you've run out of time, run out of time, you say the counsel seeks permission to read out the prayer for the benefit of the court. Now you say the benefit of the court because how does it benefit the court by you reading out your prayer? So when you read out your prayer, the relief that you're asking goes into the conscious memory of the judge in the real life courtroom practice and in the memorial moot court as well. So then it goes to the subconscious mind of the judge, and he starts to analyze, or she starts to analyze your arguments, that this particular counsel is seeking this particular relief from me, and he has argued this in his oral submissions previously. So then they can conclude, or they can infer a overall judgment of your case very well. All right. With this, I invite my co-speaker Priyanshi Jain to proceed with the slide.
Thank you so much, Ayush. I am pretty sure this session is going to be very helpful in my next mood as well. So we'll move on to the next slide. Hi guys, I'm Priyanshi Jain and I am a third year student at Campus Law Center. We will be moving on to certain general things that, like, most of it was covered already. This is a caveat that there might be certain things that are repeated during the next half of the workshop. And remember that this is being repeated only because it's very important. So yeah, just keep taking notes, and in case you have any questions, drop them in the chat box. We'll talk about something very important, that is addressing judges' questions. So, judges, you have essentially 10 minutes to cover an entire argument. You need to make your entire case in those 10 minutes. Now, and a lot of you will be arguing in front of the same judges. So, they might be very well aware after a certain point of time as to what sort of arguments, let's say, are coming from the plaintiff side and the defendant side. So they might start questioning more eventually as the rounds proceed. This doesn't mean in any way that the people who will be going in initially would not have questions, but just get an idea, right, that when once the judges start to get more aware, they will start asking more questions. And in general, these questions, how do you take them up? Firstly, be very, very calm when these questions start to come to you during your rounds, because people tend to get a little confused, or your mind might be at the fact that, oh, you have to complete your arguments. But just stay calm, listen to the questions very carefully, and whenever a question is asked, firstly acknowledge the question by saying thank you, judges, for the question. Then take a minute to answer. You do not have to rush to answer that question. The judge has asked you a question, take your time to collect your thoughts, because you are not being marked on how instantly you answer that question. You are being marked on whether or not A, you know it, and secondly, how well you structure that answer. So you need to have, it's amazing that you would have knowledge of your issue at hand, your mood problem, but you need to have that sort of presence of mind where you are able to answer those questions. And that will only happen when you take a moment to realize what was asked. And you do not have to answer in a verbose manner. You do not have to say, XYZ happened, YZA will be happening. And you just need to stick to your question. You do not have to go left and right. And that will only happen once you hear the question very well. So that is one thing. Then, if you do not, let's say, understand the question, or if you are not able to hear the question very well, you will very calmly ask the bench, okay, your lordship, if you could kindly rephrase the question, or your lordships, if you could kindly repeat this question. Now, this is very important because, again, you need to understand the question very well before you answer. Now, there might be situations when you are not aware of what the answer is, which is okay. The judges are aware that it's an induction moot. This is your first moot. They are very well aware that you might, like, as law students and even as lawyers, you can't always be aware of everything in your case. So in such situations, as Ayush has already mentioned, you can always plead ignorance by saying the counsel humbly pleads ignorance. Now, like Ayush said, you cannot plead ignorance when it comes to your facts, because facts are something that lawyers should have very handy. It should be on your fingertips. You are supposed to know what has happened in your case. But in case of a question of law, or in case of any other questions, you can plead ignorance. So that is one thing. Then keep certain phrases handy, like the counsel humbly submits. This has been emphasized a lot of times during our workshop, and we are going to emphasize on it a lot more, because it's very important to first refer to yourself as the counsel and then humbly submits. Then you can all there might be a situation where, let's say, you are the counsel for defendant and the bench says that, oh, but your defendant did this, he's wrong. In such situation, what are you going to say? You can't say, no, judge, you are wrong. That's not the way to go about it, right? So the counsel respectfully would like to disagree. Respectfully is an important word. Of course, if you don't use it, it's not the end of the world, but try to use it as much as possible. The counsel respectfully would like to disagree. Now, then there is the counsel would like to respectfully add. Now, there might be a situation when you are agreeing with the judges, but there is another angle to your particular situation which you want to mention, right? So let's say your judge is saying that, okay, your defendant was present at an XYZ location where the murder happened. You can always say, the counsel would like to respectfully submit that yes, the defendant was present there, but but the counsel would respectfully like to add. Now, this is where you say that, oh, but there is a different angle to the situation. So that is another thing. Then there is the counsel humbly concedes this point and submits to the decision of the court in this matter. Now, you need to understand that there are situations where, think about it, a moot problem is made in a manner where both sides can argue a particular case. So what essentially happens is there would be certain points that will be going against you in a particular argument, and it is okay. The judges are aware of it. In such situation where, let's say, a judge is constantly pointing out that, oh, but this is wrong in your case, or oh, but your defendant was present at that at that location, what are you going to do about it? You are going that the bench is satisfied with your answer, that the bench does not need a further clarification on your answer. So before moving ahead with your further arguments, it is always advisable to say, if your lordships are satisfied, the counsel would like to continue to the submissions, would like to argue on this, your discretion. And just to note this, these are not like, you do not have to use them verbatim, but there are certain words the use of which is advisable. Can we move on to the next slide, please? Thank you. Now, certain things that have to be kept in mind. The template that we have been talking about, the notes that we have been talking about during the workshop, always remember, it is not set in stone. It is not a script that you need to read out. It's not an audition. What you need to make sure is those are just certain points that will assist you while you are doing your oral arguments, because oral arguments are very dynamic in the sense that you never know what to expect. You can it depends totally on the bench. In mooting language, there is something you called a hot bench, and then there is something that you called a normal warm bench or a cold bench. Now, what is the difference? A hot bench is a bench that just keeps shooting on questions, whereas a warm bench is a bench that listens to you, maybe asks a couple of clarifications, but does not intervene a lot. Now, you need to roll with the dice. If you receive a hot bench, you cannot get startled there. You do not have a lot of time to adapt to it. You have essentially 10 minutes to give your entire argument. So you need to have those pointers. A good use of those pointers in this situation would be if you are answering those questions, because then what happens is that you are able to cover your issue and you are able to answer and satisfy the bench. And while, like, you must be having a flow of your arguments, right? You have, let's say, issue 1, sub issue 1, 2, issue 1 of issue 1, but you are asked a question from sub issue 2. What will you do? You will answer. You would not say that, okay, I will come on, the counsel will come on this later. No, you answer that question then and there. Then you complete your first sub issue, and then when you are at this, you say that you just give a brief 1-liner, 2-liner in your sub issue and say that, okay, this previous question. So basically, what we are trying to tell you here is keep yourself dynamic. Don't try to be extreme when you are sort of just going with your pointers or going with your memorials, this thing, flow of arguments. And always remember that every statement that you use in a court, in a moot courtroom for that matter, is is an argument. It has a purpose. You arguments. Don't use unnecessary statements just to prolong your time, because 10 minutes honestly is not a lot when it comes to summarizing a case for a client. Another thing that you need to make sure is that do not, you know, do not, you know, rush through. Like I said, do not try to complete your arguments in that set tone. You will have to juggle. If notes for our oral arguments, we have told you, do not your memorial. You would not be able to complete all your arguments within the allotted time, because normally if you sit and read through your memorial, it is more verbose. It has more the counsel humbly submits, and then there is division of points in a manner that is a little more elaborate, and that is something that you would not be able to cover during your 10 minutes. So make sure that you do have individual notes. Now, uh, just ensure that the judges are with you. Why do we say that? Because judges are also sitting and listening to a lot of people during the day, right? Now, you need to understand it from a common human tendency that the judge will probably, it's going to be hot. Judges will be tired. Judges will be thinking about, oh, I have to get back to this. I have to get back to my files, the files that they have as lawyers. So what happens is there might be times when they are not with you. So do not try to read completely, because when, let's say, if I'm doing this the entire time, if my head is down, I would not be able to have that eye contact. I would not be able to keep a track of their expressions to see whether or not a judge is with me. And a very good trick to keep your judges with you is to refer to either your memorial or a certain, mostly your memorial. You do not have compendiums in FIM, so your memorial. So maybe if you're making an argument, let's say you're referring to a case, X versus Y. Now you have mentioned your X versus Y on page number A in your memorial. So you say, okay, judges, kindly refer to page A in case X versus Y in paragraph 1. This is what is happening. So that ways you make sure that the judges are actually listening to you, and your arguments are not lost in the vacuum. So that is very important. There might be a situation where your time is running out. Let's say you're left with 3 minutes and the judge is just not like stopping the questions. What do you do in such a situation? You make sure that you answer their questions. You tell them that, judges, due to paucity of time, I would like to move to my argument after you are done answering their question. And try to keep summary points of your is that important, because let's say you are like, there are a lot of questions that take a lot of your time. In that case, you just refer to those summaries and you summarize your points. You say that, okay, I feel X is not guilty because ABC happened. He was not there. He did not have an intention. He did not, the weapon that was recovered did not have his fingerprints. And you just, now, approach your oral arguments as a conversation. Now, this is very important. A, because you need to ensure that your judges are with you. If you interact with them, if you, treat it as a conversation where you're trying to make the other person understand what you're saying, it will be easier for you. You will leave a more lasting impact. Engage with them, respond to them, and don't read it as a speech. If you start reading it as a speech, they will lose interest, because if basic human tendency. Very important, prepare a list of anticipated questions and have point wise notes made to provide an answer. So let's say, I think the FIM situation, you have a contract issue. Now go through the contract act, make sure that you are aware of what sort of questions can be asked to you. Let's say, now this is not a part of the FIM problem, but let's say you're arguing a point of consideration. Now there is a possibility ki, okay, if you're saying that okay, this much is the consideration, the judge might ask you whether or not that consideration is enough, whether or not this would make the contract binding. So when you are arguing an issue that is, let's say, undue influence, let's say misrepresentation, whatever, ensure that you have a list of anticipated question, and don't just stick to that particular problem. Let's say your problem is misrepresentation. Ensure that you are aware of what misrepresentation is, but also that you are aware of what other circumstances around that particular provision are. When is a contract voidable? Let's say there's an issue. When is a contract voidable? Your situation is undue influence, but there are other situations also under which a contract might be voidable, right? Now you have to make sure that you are aware of those situations, because during an induction moot, or in any moot for that matter, judges like to see whether or not law students are aware of what is happening, whether or not they know the law. So to know the law, you just can't stick to what is asked point blank in your moot problem. You need to be aware about things that are happening around it as well. If you are saying that this is in undue influence, you also have to tell them why this is not misrepresentation and only undue influence. So yeah, that is also very important. Next slide, please. uh, right. Never speak over the judge. It is very important. As soon as they start speaking, you just stop mid sentence, mid word, it doesn't matter. They are the judges, they are not your equals. They have the right to cut you in between your sentences and words, but you do not. So let them finish their sentence. Even if you anticipate that their sentence is ending, you take a second after they have stopped speaking and then continue, so that it does not show that okay, you are either getting impatient or that you're trying to cut them. So that is very important. And another point is that there are a lot of questions wherein it's either a yes or a no, and then there is a reason for a yes or a no, right? So if that is the situation that you are having, let's say a judge asks you a question and the answer is yes, you say yes first to establish that position, that okay, yes, this is the case. Okay, I am the judge, I say, do you think that this is a case of undue influence? You say yes, your honor. Then you tell them that why do you think it's a case of undue influence. Or if you say that it's not a case of undue influence, you say no, your honor, or no, your lordship, this is rather this. So whenever there is a point blank answer to your question, always start with a yes or a no. Then I'm not sure how many of you are aware, Ayush also covered this, that there will be a court master in your courtroom who will be showing you the time that is left with you. So you have 10 minutes. They will essentially show you 5 minutes left, 2 minutes left, and time's up placards. You need to make sure that you keep up with them in order to be able to conclude your arguments in time, because even though there is no explicit mention of time management in your scoring, judges do consider that, because at the end of your arguments, the court master will also tell the judges that okay, participant 1 took x minutes. So that sort of reflects on your score somehow. Another thing that you need to make sure is, let's say the court master has showed you 2 minutes left, but your arguments are probably going to take 2.5 minutes, 3 minutes. You can always ask for an extension even when they have showed you a time's up. Instead of just continuously speaking over their time's up placard, you can say, the council would like a minute's extension, or the council would like 30 seconds to wrap up their argument. So that is always a good practice, because it shows that you're seeking permission of the court before going on with whatever it is that you want to talk about. So yeah, that is also very important. Another thing, that during your question and answer, it's not like the timer stops. So if the judge is asking a question, you are answering the question, that time is included in your 10 minutes allotted time. um, Even if the judge is like continuously speaking for a minute, there are certain questions that need a little bit of context before they are asked. So if the judge is, just if the bench is establishing that context and taking their time to ask you your question, that time will be lapsing from your speaker time, and you have to manage accordingly. So yeah, time management is very important. Of course you can take extensions, but that is at the complete discretion of the judge. It is a possibility that mid argument you are asked to wrap up your arguments or to conclude with your prayer. So be ready for any situation. Next slide, please. So, certain general do's and don'ts. Of course, we've been telling you, and you all are aware that the dress code is black and white formals. Make sure you stick with it, because, again, the way you carry yourself, the way you speak, your demeanor, whether or not you're calm, whether or not you're speaking very hurriedly, all of that adds to your scores. Calm and collected, of course. Another very important thing, see, there are people who speak very fast. I am one of those people who speaks very fast. But you need to make sure to talk in a speed that the other person is able to understand what you're trying to say, because in your head you might be making sense because you are aware of what you are going to speak. So if I know what I'm going to speak, I know it's making sense to me. But the other person does not know what I'm going to speak. They need time to process that information in order to be able to make a decision as to whether I'm saying the right thing or the wrong thing, and then accordingly ask me questions. So make sure that you speak at a pace that is comprehensible, not just by the judges, but by anyone in general. So you can, in fact, take a practice sessions with your family, with your friends, so that it gives you an idea of how slow or how fast you need to speak, and what can you sort of tweak in order to be able to complete within time. So even that is very important. Then again, time your arguments to ensure that, I've already mentioned that your timing really means a lot during your oral arguments, because not just in terms of time management, you if you're not able to complete your issues, how do you expect a judge to mark you on that? Because each judge has a different sort of manner of marking. Now they might think that, okay, they will give you, let's say, for oral arguments, for speech itself they have allotted, let's say, 30 marks. So they might think that, okay, for first issue they'll give you 10 marks, for second issue they'll give you 10 marks, so like that way. So you do not know in what way has that particular judge divided his marks, and you need to try and complete your arguments. If not completely delve into it, at least touch upon them. Go through your memorial multiple times. Please ensure that you have nothing on your memorial that you're not aware of, be it facts, be it statute, be it case laws, because that reflects very badly on you. If I am asked a question and from my memorial and I'm not aware of it, the judge will obviously think that I have either copied it or from a fellow mooter, or I have probably chat GPT'd it. So that is also very important, to make sure that you know everything in your memorial. Um, a good practice would be to sort of create a roadmap of your own memorial on a note, like a small note where you know what is mentioned where. Use bookmarks to ensure that you're able to flip through your memorial very easily. That helps. And like I said earlier, try to cover related concepts to the topic at hand, because that helps. I remember, I think, during my induction moot, I was inducted through a common induction moot, so I did not have a contract problem. I had a different problem, and I was asked the difference between homicide and culpable homicide, if I'm not wrong. Culpable homicide not amounting to murder, and murder. So I was asked such a difference. So make sure that you know related concepts, that you have clarity of law, at least, if not like how to apply that to your particular situation. So yeah, that is that. I think most of these things I have covered from my end. If you have any questions, probably out of slides, but I would want to give certain other tips. Don't try to move your hands a lot. So I am a very expressive speaker. You have seen me move my hands a lot during the entire presentation, but you can't be aggressive with your movements. Even if you're using hand movements, make sure that they are sort of limited to your space, because you are addressing a bench. Now when you address a bench, what you need to make sure is that you know that they are not your equals. You are presenting your case to them in order to um, get a favorable decision. You can't seem to be aggressive at that point of time. If you seem aggressive, they might feel offended about it. So a lot of hand movements like this, whatever, it might seem a little aggressive. So make sure that your hands are poised. You don't use them a lot. If you are speaking and you do not need to refer to anything, keep it on the podium. Even that is fine. Another very important point, try to carry the Bear Act. I know you will have most of the things in your memorial itself, but carrying the Bear Act is a good practice, because there might be a situation where the judge asks a clarification on a law that you have not used. Um, Related topic, like I said. So in that case, it's always better to refer to your Bear Act to see what is written in order to be able to answer that question. Use flags, very important. You should know on which page your particular issue is starting. So adding flags always helps with referring to your own memorial. That is very important. And yeah, that is, I think, pretty much what I would want to cover. I hope I'm not missing on to anything. If you guys have any questions for me, for Ayush, we are open to questions right now.
Although I think Priyanshi has almost covered it already, but I'll again put emphasis on the dress code. So there were many students who asked teachers as to, are we supposed to wear the black coat, white shirt? So the answer is yes. Please arrange or buy a black coat. Even if you don't buy it, arrange it from a friend. But you need to be in courtroom formals. So that is white shirt, black coat, black jeans, black pants, and black shoes for men. And for the females, it is a black coat, white kurti, and white
Shirt also, shirt,
yeah,
kurti, anything works.
any
Uh,
which way.
I mean, guys, you need to understand that lawyers, even if it's hot, it's cold, it doesn't matter. They have to wear that black coat inside a courtroom. So you guys are lawyers. You need to make sure that you have your coat on you. It's
And
like a
also,
lawyer's armor.
the fact that you've joined Campus Law Center already means that you're already half advocates
Exactly.
and you're supposed to buy a black coat. So please go ahead and make that investment. You're not going to regret it. It's very required in your coming 3 years. So that is
And
that.
after that, hopefully.
After that, hopefully as well. So in the end, if anybody else has any questions, any doubts to be asked, feel free to unmute yourself and ask us. Nobody? All right. With
So
that,
if there is a mixed bench, uh,
could you
so
please
I
come
wanted to
again?
ask that, yes. So I wanted to ask if there is a mixed bench, so how should we refer to them? Your lordship or your ladyship?
So, okay, Ayush, you can take that question.
All right. So in the portion where yes. So kindly refer to the fourth point herein that you seek permission from the bench, that the council seeks permission to collectively refer to the bench as your lordship or your ladyship. That can be as per the convenience of the bench itself. If there is a mixed bench, they can say that you can refer to us as your ladyship, you can refer to us as your lordship. So you use that throughout your oral submissions. And
Mostly,
also a small nuance, if you notice that before you seeking permission, the council seeking permission, you don't say the council seeks permission to approach your ladyship or your lordship. You say the bench because bench is a very neutral word, right? It doesn't take away the character of any mixed bench. So after that, you say the permission to approach in a certain fashion, certain word that you're proposing to use, and the judges allow you that. So after that, you use that only. All right. Somebody else also raised their hands. You want to say anything, Priyanshi?
yeah, I was just gonna say,
All
if
right.
it's a mixed bench, the normal practice, as sexist as it may sound, is calling it your lordship. So you need to ask them, and they are mostly comfortable with your lordships, or you can ask them your. They might tell you to call them your honors as well, or the bench is also fine at times if they are comfortable. But normal practice is your lordship if it's a mixed bench.
I think somebody else raised their hands. If there is anybody. And also, guys, this is not a script. Whatever we have shown you, we'll be sharing a PDF of this slide soon with you guys for you to refer to it. But this is not a script. You can always add in your own variations, your own trial and hit methods that you don't like saying this, so you can say that. For instance, that we've told you to ask permission to collectively refer to the bench as your leadership, your lordship. If you don't want to do that, you can say the bench that the council humbly seeks permission of the bench to collectively refer to the bench as the bench. Very weird it sounded, but anyway. Shivesh, yes, please.
Yeah. So suppose we have not included something in our memorial, like suppose during the suppose what is the proceedings, like if the judges ask some question which I maybe I know through a case which I have not mentioned in my memorial or something which is not mentioned in my memorial. Can I like can I argue on that case particularly without as it is not mentioned in my memorial or something on the same lines?
Answer, you take that?
Yeah, so I'll take that
Okay, okay.
question. So the best practice is to not go beyond your memorial, at least when you are giving your arguments, because your arguments, it's not even the best practice. You have to be limited to what you have already submitted as written submissions. That is what the case is. However, if it's a question from the bench and you are aware of a case law or of another law that might back your situation, you can use it. There is no hard and fast rule to stick to your memorial when it comes to questions. But if you're making a point that is not a question, that is something that is a part of your issue and sub issue, you need to stick to your memorial. I hope that
That
answers.
answers it. Right.
Yeah, yeah. Yes.
Anybody else? Any other questions? So, all right, everybody. With that, we wrap up the last workshop of Freshers Reduction Mode 2025. I am Ayush Rana. I am the student interim convener of Moot Society, along with Priyanshi Jain, a third year executive committee member of the society. Thank you so much for being a lovely audience, and all the best to you guys for your oral submissions.
All the best, guys. Have fun with your moot. It's your first moot. It's going to be a good experience, hopefully. Don't get worried. There are questions, but there would be nothing that you should be feeling intimidated about, because the judges are aware that you are first year students. This is your first moot. So have fun with it. That's very important.
Thank you, guys. So, good evening. Enjoy. All the best.